Good morning, everyone, ladies and gentlemen. Thank you very much for joining us, this being the third in a series of webinars given by Shepherd and Wedderburn on alternative dispute resolution. Today's webinar will cover the subject of mediation. And thank you particularly for joining us in this most solemn and sad of weeks, given the passing of the Queen, which I'm sure is impacting upon everyone's working arrangements. Today, an associate within our dispute resolution team in London, Lily Manser, will be giving an introduction to the subject of mediation, and then we'll be moving on to Andrew Miller, King's Counsel, who will be talking about his experiences in broad terms as a mediator who's operated in the field for a number of years and can give some very useful practical pointers on the conduct of mediations and to learn from the experience. As is always the case with these sessions, we're very keen to receive any questions from you in relation to matters that occur, so please feel free to send your questions in the Q&A box at the bottom of the screen. We'll endeavour to deal with them at the end of the session. If we can't deal with them then, we will of course follow up in correspondence. Very happy to do that. Last thing to say is that this webinar is being recorded and scripts and bios in relation to everyone participating shall be sent to you all if you wish to receive them at the end of the session. So without further ado, let me hand over to Lily, and thank you very much again.
Thank you very much, Philip, and good morning, everybody, and thank you very much for attending today's session, and welcome back to those of you who have joined our earlier sessions earlier on in the summer. So as Philip touched upon, today's session is sticking with the themes from our earlier webinar series, and we'll be focusing on the topic of mediation. As we have touched upon in earlier sessions, mediation is another form of ADR. Mediation is a flexible, voluntary and confidential form of alternative dispute resolution in which a neutral third-party mediator will assist parties to work towards a negotiated settlement of their dispute, with the parties retaining control of the decision on whether or not to settle and on what terms. As Philip has mentioned, we have a guest speaker with us today, Andrew Miller Casey, who has had a successful 30-year career as a top-ranked commercial construction and insurance King's Counsel, and now practices principally as a mediator and arbitrator. Andrew is known to lawyers at our firm and has acted as leading counsel on a number of claims that have seen favourable outcomes for their clients. By way of further introduction of Andrew, he has experience of over 150 mediations and has been involved in mediations both domestically and internationally. His sectors cover construction, property damage, insurance, reinsurance, professional negligence, and general commercial disputes. As a firm, we have vast experience of conducting and advising on mediations, as well as other forms of ADR, both in person and remotely. And we've seen successful settlements negotiated for our clients, either at or following a mediation. And whilst I'm sure we could all speak for a very long time on the topic of mediation, I am going to pass the baton to Andrew, who's kindly agreed to share the benefit of his experience with us today. And once Andrew concludes his section, as Philip mentioned, there will be a Q&A with the panel, and you can send your questions to us in the usual way by the chat function. So without further ado, I will pass to Andrew Miller.
Thank you very much, Lily. Thank you, Philip, both of you, for the invitation and the very kind introduction. It's taking a bit of getting used to being referred to as Casey rather than QC, but I'm going to have to, those who can see, if you can see my old photo, which still has a plaque that says QC on it, I'm going to have to change that. So Thank you for that. Let me just tell you very quickly a bit about me. You've heard, because it puts it into context, I hope. As Lily said, I have been a barrister. I shudder. I can't see many of you, but I dare say there are many of you on the call who are younger than the 33 years that I have been a barrister, or at the very least were incredibly young at that stage. I know all of you looking at the screen, it must come as a huge shock, but I did start in chambers when I was 6 years old as a child prodigy, obviously. So for most of those 33 years, I was what I would call a regular commercial barrister. I was on one side or the other. I was fighting a case. I did quite a few cases with Philip Sewell over the years, involving matters in this jurisdiction and overseas. And I actually got to travel with Philip, which was a joy. And I, as a barrister, I think I'm in a minority that I actually got to see mediation very early on. And it was at the beginning of the 90s, in about 93 or 94, at a time when mediation was not talked about in the UK. I was lucky to be instructed by an American firm, hence why they wanted to try mediation of a construction dispute. It was an international dispute, and when they told me all about mediation, and they told the Queen's Counsel I was being led by, it was all new stuff to us. But what I actually saw on the next day, and it was actually a mediation over 3 days, was a process that I was totally unfamiliar with, had never been taught to me at university or at bar school, or even mentioned in chambers during pupillage or my early years as that was. So I then became a very big fan of mediation as counsel, and would often recommend mediation to my clients. I wasn't always a massive fan of mediators, because we're a mixed bunch, and we still are a mixed bunch, and we have different approaches. But having these quite strong views, I finally decided to sort of put my money where my mouth was, and start, rather than sitting there as counsel in a mediation, actually starting to mediate. And I started doing that. I think I'm coming up to about 8 years of that. I kept doing both, being a barrister and a mediator, but I found when I put my toes in the mediation pond, they got nibbled pretty quickly, and I started building up my practice. And the whole thing is, and one of the reasons why I then moved over completely now in the beginning of 2018, so over 4 years ago, to being just a neutral, is because I found that's what most clients wanted. They didn't want someone who was coming in to mediate their cases to still be working as a barrister, potentially on for clients that might be related, etc., and especially the type of work I did with a lot of insurers. So I effectively moved. I always like to say or joke that I moved from being poacher to gamekeeper, in the sense I was no longer fighting for one side, but I was trying to pull them aside. I see we have, I can't see you, but I see we now have 45 people tuning in. And I know, and I've been told that a lot of you know what mediation is, etc. So this isn't going to be a talk explaining it. And I hope most of you understand the concept of a neutral. But just in case, what separates me and any other mediator when I come in to the room to get parties together is I am not in the position of a judge. And the best way I use to explain that as a mediator is it means I don't care who is right or wrong. A judge, he or she does care because they have to make findings. But as a mediator, I don't care at all who's right or wrong. I don't care what the interpretation, if it's a contractual case, is. I don't care who's going to prove fraud or not prove fraud, or the factual cases. But I come in as a neutral with a completely different role, and that is caring passionately as to whether I am able to do something with the parties in a very short period of time to get the parties to be in a state where they are able to start negotiating and hopefully able to negotiate a settlement of their dispute. So a lot of mediators says, I'm here just to get you to settle your case. There's a lot of steps to mediation I think a mediator has to have, and I see it as stepping stones. I have to get the parties into that position. When I now mediate full time, and when I'm asked, how many mediations of yours have you settled? My answer is always 0. I've settled none, because in the end, my job is to get the parties into that position of negotiation, help them with the negotiation, facilitate that negotiation, but it's the parties in the end who are going to settle it. So it's always the part, hence my 0. It's always the parties. I'm not going to try and sell mediation. Hopefully, I don't need to, or the advantages. And the reason I say that, I'm not going to try and persuade anyone on the webinar to use mediation. And the reason for that is because most people involved in litigation should already know the advantages of mediations and should not need that persuasion, as the reasons for mediation speak for themselves. If you are commercial people, and I know the practice of the firm very well, so my assumption is all, if not most, if not all of you are commercial people, you won't need this, because the advantages of mediation just sort of scream out. It's affordable. It's far more cost effective than traditional litigation. And that affordability, and I'll come on to one of the main things I want to talk about, which is the timing of mediation. The earlier it is, the more affordable it is, and it's certainly hugely more affordable than taking the matter all the way to trial. Mediations, the mediation process itself, the actual mediation day is often a day. Sometimes it's 2 days, but the build-up is relatively small compared to the build-up of trial. And of course, the 1 day is a lot cheaper than a 5-day trial, 3-week trial, whatever, etc. It is efficient. It's an efficient use of time, and I use efficiency not simply in terms of the legal aspects, but it's efficient in terms of party aspects. You're concentrating on trying to get the dispute to an end in that short period of time, that 1 day. It's accessible, and it's even more accessible now. As with everything, when COVID struck, mediations went online. I did about 75 online mediations myself. I have my own personal reasons. I far prefer, and I always encourage those parties I'm mediating for to meet in person. So having gone back to in person, I'd say now 90% of my mediations are back in person, but the accessibility point still applies, because a lot of my mediations, we may be meeting in person, but there may be individuals who can't be with us, but they can be with us through a screen for the mediation. It has huge flexibility. Next thing, it's flexibility to consider a multitude of issues. There's nothing better in a mediation when there is a litigation, there's a dispute in place, and that dispute you could put into a nice package, but somehow in the mediation, the issues expand, and maybe the parties are working with each other on other projects, maybe there's other disputes pending, and suddenly you have this flexibility to bring in a lot more into the mediation sphere, into the mediation room than you would otherwise. And that's great. So there's many mediations that I've had that start with 1 dispute but end up settling 2 disputes or even more, or actually as part of the settlement of the dispute, entering into a new contract. I had a mediation in Cardiff on Monday. I actually went into Tuesday as well, and that's exactly what happened. It started just being after money, but it ended with 5 companies changing hands and individuals being appointed to run those companies. At the beginning of the day, or the beginning of the 2 days, no one envisaged that as being anything that could happen. But that was huge flexibility and gave an outcome that was far better on both sides than anyone had anticipated. And finally, it's effective. And the statistic that is always given is about 75%, 75 to 80%, etc. And that's about right for commercial mediators, or I should say for the sort of mediators that do my work. It's about that. It still means that 1 in 4 don't settle. And I'm always keen to tell the parties to remember that. But the 3 in 4 is very high. It means you have a 75% chance of your dispute being at an end. Yeah. And that brings me really, it's something that's not talked about enough. It's why I was always a big fan of mediation. I talk about mediation in the UK and all over the world, and I beat this drum. And there is a reason for mediation. There is a purpose to it, and that is to bring a dispute to an end. And that's what needs to be concentrated on, whether you are the user of the mediation as a client, or whether you are the lawyers. And I give lots of talks, I give training to solicitors, to barristers, to in-house counsel. It's concentrating on that end goal, and realizing that what you are seeking to get out of the mediation is 2 things, but in fact they're actually the same. Now, you're seeking to get out, to bring this dispute that you are in with another party, it could be a multi-party dispute, to an end. And that end is a settlement, whatever form that settlement takes. And the phrase I like to use, especially when I'm training solicitors to be, or barristers to be mediation advocates, is what you are offering your clients is what I call the gift of settlement. And for me, that gift of settlement is the gift that keeps on giving. And selling that, and that being sold to you, or you as clients, and you are those attending a client, it's really important. And the reason why it's so important is, and it took me, now having become a mediator, and as I say, poacher turned gamekeeper, I've had to at times put mirrors up to myself and ask myself, how was I with my clients? How did I behave with my clients? Did I push for settlement or not? Because the one thing I think it took me a lot of years to learn is that clients prefer not to be in dispute rather to be in dispute. And that actually came home to me very recently. I think it's this year. I'm lost track. We're in September, aren't we? It was this year, and it was the London International Disputes Week, which is a week that happens every single year. And there was an in-house counsel who stood up and gave a talk. And most of the people in the room, I think, were solicitors and barristers. And stood up and made this line, said, when one thing that has to happen is that you lawyers need to understand that the most important thing for us is that we're not in dispute, is that we're out of dispute. And so what your aim should be is not necessarily, sometimes things have to go to trial, there's no doubt about that. Sometimes they have to be adjudicated, but generally speaking, we as commercial people, we want to make money. We don't want to be in dispute. And so what's relevant about this is, and what's been missing very much, mediation has been in the UK and has been used now for the best part of 30 plus years. It's educating users of mediation, and by that I mean clients, corporations, in-house counsel, actually CFOs. I often get told by CFOs they didn't know enough about mediation before they came to the mediation itself. But getting them to understand what it is. One of the problems I think there's been is that, if I can call it the mediation basket that sort of existed for a while, arbitration and mediation were put in the same basket, and they're hugely different. And that's what's caused a bit of confusion. Arbitration, as I'm sure most of you know, is simply private litigation. And instead of a judge, you have an arbitrator or arbitrators who make the decision. And it's still a determinative process. In other words, someone at the end, or in the case of 3 arbitrators are going to be making the decision. Mediation is totally different. It's self-resolution of a case by the parties with the help of their lawyers, with the facilitation of the mediator. And putting them in the same basket has been some confusion. And what that's also led to is mediation really being attached to litigation. So people aren't thinking of mediation until they're in litigation. And mediation has actually become an adjunct onto litigation. And it's something that the States has actually moved away. The US has moved away from a bit. And you'll find a lot of the firms have trial sort of tranches of cases, but they have separate mediation tranches cases that may never see any litigation at all and just go towards mediation. So that's sort of where we are. For me, it's all about learning what mediation, what it can do for you. In short, what it can do for you is it can bring your dispute to an end. So one of the hottest topics, and it's been a hottest topic for years and still is, and there's a lot of views on this, so I should caveat this with saying these are my views, and that's around timing. And it's when should the parties go to mediation? And there's lots of arguments around this, and there's lots of lawyers who will tell you can't go to mediation until we've done X, Y, and Z, until we have witness statements, until we have expert reports, etc. And for me, there's no right or wrong answer. Each case has to be looked at on its own merits, etc., where the parties are in terms of their relationship with the other side. But my mantra, if I'm asked when is the right time to go to mediation, is simply to say the sooner the better. Whatever that means in terms of each individual case, the sooner you can get to mediation, the better chance you have of falling into that 75% rather than the 25%. Yeah. You can spend a lot of time, a lot of money arguing about whether you need the witness statements, whether you need the evidence, etc. But for me, what happens is there's 2 things. The longer you wait to go into a mediation, the further away you move from the dispute itself. And so when I actually gave one of my first talks on mediation, which is going back to, I think, 2015, it was in person, and I was making similar comments about sooner the better, and someone at the back of the room sort of shouted out, are you saying it's never too early to go to mediation? And I had to think on my feet. And the answer I gave, which hasn't changed over the last 7 odd years, is it may be that the mediation is too early to achieve a settlement itself, but it's never too early for parties into dispute to start talking about that dispute, why they're in dispute, how it's led to dispute. Because even if they don't get a settlement at that stage, they've started the dialogue. And once they've started the dialogue, it's like dominoes falling. That will continue. It could lead to a settlement a week later, a month later, even a year later. But it's never too early to start talking about it. And I think one of the things is to look at what happens in litigation. And I'm a big supporter of litigation. I was a litigator for many years, and so I'm not taking away from the importance of it, but there's a huge difference as to where we are. If I make a comparison, if I may, with doctors, when you go to a doctor and let's say you have a rash on your hand, and you tell the doctor, I've got a rash on my hand, what you're actually saying to the doctor is, I want my hand to be as it was before the rash. And when people go to a lawyer with a problem, it's no different. I was selling tables to Italy, and everything's been going good for years, and now they haven't paid, or I'm buying tables and they're defective. What anyone's actually saying is, everything was good, but now I'm in dispute, but I don't really want to be in dispute. And the issue with litigation is, unlike the doctor putting you back in the position you would have been, you take the parties on a journey. And that journey can just get longer and longer and longer. And we know, and I've been involved in many pieces of litigation, I see the mediation I had in Cardiff on Monday had been going for 4 years, the litigation. And the parties have moved so far away from what was the original dispute that they almost basically forgot why they were in dispute. They understood the dispute and also the legal arguments, but not why they're in dispute. And so one of the skills of the mediator is taking them back to where they were, etc. So it's taking them back, but it's all about being at that point. What can we do now? What can we do to get a settlement? So what I say, and as a user mediation, what else do you need? Let's say you've decided, you've been told, and Shepherd and Wedderburn, I know, are excellent at discussing mediation with their clients, etc. So this is what I also, my top tips going forward, is it's really important that you as the clients are involved from the beginning of the mediation process. Now that process can actually be very, very small. It can be a matter of weeks. It can be a matter of months. From decision to go to mediation, agreeing with the other side, there should be a mediation, etc., choosing the mediator. It's important that you're involved with that. And I think it's quite rare that clients are involved with the choice of the mediator, because there are different types of mediators. And any good mediator will actually offer the chance to solicitors. The solicitors in many of my mediations I have never known in practice. I give them a chance to speak to me, but I also say to them, let your clients have a chance to speak to me on a no obligation basis, to tell them what type of mediator I do, how I propose to do it, etc. And for a client, that's really important, because you may not like that mediator, or you may like that mediator, and you may want to use he or she the mediation. But more important, you'll be able to ask questions of the mediator to get a feel, anything you don't know about mediation, to get a feel for it, etc. Once a mediator is appointed, it doesn't end there until the mediation day. Any good mediator will have pre-mediation contact with both the lawyers and the clients. And again, it's a bit of a battle that I have, and I know many mediators have, to actually have both lawyers and clients. And so I have this opportunity to speak to clients. I say, get involved the early stage. The lawyers are on the call. Get your clients involved to actually be in those pre-mediation discussions, because it means you've jumped over quite a few hurdles. It allows the mediator to talk about the mediation processes, what's going to happen, tell you about the confidentiality aspects of it, but also have a chance to get to know you. Because for me, there's nothing worse than a mediation of turning up in person, or if it's remote, turning on the screen, and then meeting people for the first time. So it gives you a real chance to do that. The other thing is, and this is the most important, when I decided not to use slides, because everyone's getting a little bit PowerPointed out, but when I'm using slides, one slide I have, the title is Preparation for Mediation, and then I click and it says, the next line says prepare, 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 and I click again and it says the same thing again, prepare. Depending on my audience, how many clicks it gets, but I think the maximum is 6. So the screen is just full of prepare. And that's really, really important. And it really helps It applies, to the solicitors if there's barristers involved, but also I stress to the clients to be prepared for the mediation. You would prepare for a trial. Your preparation for mediation is going to be less than for the trial, but it's really good to know where you are. But there's quite a difference. You are preparing in a slightly different way. When it's gung-ho, when you're going to trial, and it's still the case that some matters end up in trial, of course, you are doing everything to prove you are right and the other side is wrong to the judge. Preparing for mediation is different. It's thinking about, what do I need? What is going to be the best thing for me, for my company, etc., to bring this matter to an end? It's thinking about that. What concessions can I make? What concessions can't I make? What's a red line for me in this? How do I think a settlement is going to look, etc.? And it's almost like the pros and cons. What are the benefits for me of settling? What's the downside for me? And it's not all about the case. It's about the effect. If you're a company, it's about the effect it's going to have, time management on you, on staff, etc. If you're an individual, it's going to be, what's going to be the effect of going through another X number of months or years on the litigation. But it's just putting yourself into a different frame of mind. And instead of being in litigation mode, you put yourself in what I call settlement mode. And it's a very, very different, a very different type of mode. And I'm going to come back to that in a moment. But to do this, what do you need when you're preparing? It's not just a question of reading papers. What else is it? Now, one of the main things is thinking about who's going to be at the mediation. And that's something that on many occasions insufficient thought is given to that, or the wrong people are at the mediation, or the mediation is missing a key person. What you need to have at the mediation are your key decision makers. Now, it may be that your solicitors don't know who the key decision makers are, because it's not always the people that have been involved in the litigation. But it's really important, because you want to be in a position to deal with everything that turns up at the mediation, to be in a position to move yourself from this sort of fighting position to how are we going to settle it. So, as I said, we have great flexibility in mediation. It doesn't, if it's an in-person mediation, it doesn't necessarily mean that that person has to be sitting in the room. But what it does mean, that person has to be available, whether it's by phone or by linking in by Zoom or whatever, etc. And that's quite crucial, and it saves an awful lot of time. And it sounds simple, but often thought isn't given to it. The other thing I've seen, and it's something that I really, I spend quite a lot of time before a mediation day talking to clients and lawyers about it. So, but it still happens. It's thinking, well, tactically, if I don't have the key decision-making person at the mediation, that's going to send a certain signal to the other side. Now, it might do, but it might send the wrong signal, and it's not going to help you if you need to get yourself into a position of where you can actually do a deal and do a deal on the day. And so that comes down, attendees is attached to the next thing, which is authority. And it's making sure you have enough authority. And when you do mediation training, one of the things you have to do to get the point, to get over to get the tick and on your way to accreditation, is you have to check in the room, do you have authority to settle this claim? Now, I don't ask that anymore, because it's almost pointless, because you might have someone who, let's pull a figure out of the air, £1 million claim. And you might have someone who says they have authority, but think the claim's only worth 50,000 and their authority is up to 50,000. Now, if the claim is never going to settle for 50,000, they don't actually have authority to settle the claim. And so a lot of thought has to be given to that, equally with attendees, as to what is the authority. Who has, is there authority in the room? And again, the same thing. If not, if it has to go to someone higher in a commercial organization, then that person has to be there. In your preparation, there's a lot making sure you know your case, etc. What your lawyers will do is they'll put together what's called position papers. And as part of my introduction to mediation, what I encourage the parties to do is not position papers, but mediation statements. And I say the mediations are slightly different because your position is clear already. If you're in litigation, you only have to look at the pleadings. You know what the position of the parties is. Mediation statements, I'd say, are less confrontational. One of the lines I use is, if your position paper or your mediation statement looks like a skeleton argument or written submissions for the opening of trial, then it's not fit for its purpose. It's not fit for a mediation. You want it to be less confrontational. You want it to cover areas that you would not necessarily say in a written opening to the court. You may go as far as recognizing weaknesses of your case that you may not do in an opening session. And the reason you can do this is because the mediation is cloaked in this confidentiality. And what that means is what goes on in mediation stays in mediation. And that's really important because it means no one can stand up at the mediation and say, well, at the mediation, X or Y said this or that. You know? And that's the legal side. But what it allows is a lot of freedom to say what you want, not simply in these mediation statements, but actually in the mediation. If you have a joint session with the other side, it gives you the chance to do that without fear that it can be used. And in fact, what mediation gives you is the phrase that's often used is your day in court, because the day in court doesn't actually exist. The day in court, the reality of a day in court is that you're told when to come in, where to stand, where to sit, and you only get to give answers to questions you're put. So many times throughout my career, throughout all the lawyers who are on the screen today, a witness will come out of a witness box and say, oh, I really wanted to talk about this or this or this. And the reason that they can't talk about it or didn't talk about it is because they weren't asked questions on it. But at mediation, you can talk about anything. As I gave the example of the mediation the other day, we actually talked about far wider things than we needed to. There was a lot of emotion, there was a lot of mistrust, there was an allegation of fraud, everything. Well, people were able to get off the party's chest, and that's the thing. And so I'm conscious of time. I'll go for another 5 minutes, so I give you time to put questions in. All this comes down to, I think I've used this phrase already, for me, which is the key to you as users of mediation and the lawyers who are supporting you. And just pausing there, for me, it is really important. Yeah, the team is important. I always see myself as the new boy on the block in mediations. I haven't been involved with it the whole time. I have to have a respect, and I do have a respect for the team that exists, who know more than me about the case, and you will work as a team. You know? But when you come to the mediation, what I encourage, whether it's the lawyers or the clients, is getting into this settlement mode. And for me, settlement mode is just understanding that you are moving in the direction, everything is geared towards bringing this dispute to an end. And what it is, it's bringing the dispute to an end on that particular day. So it's looking at what is the best settlement if we were mediating now, what's the best settlement on Thursday, the 15th of September? What's the best thing that I can achieve today? What's going to be the best thing for me, for my organization today? It may not be what would have been the best thing a month ago, a year ago. It may not be what's the best thing in a month or a year to come. It certainly won't match what could happen at trial, because there are two things that could happen at trial. You could win, or you can lose. There are things in the middle, but it's what's the best thing. So you move out of litigation mode, you move into settlement mode. And what I say is, as I said about the timing, the earlier you are, the better. And one of the things that's happening more and more and more is, and it's being pushed by solicitors on their clients, is what I call early stage mediation. There's no difference in the type of mediation you'll have, and there's no magic. It's simply what it says on the tin. The mediation is earlier rather than later. So I would say now probably 25% of my mediations are pre-action. The parties may have been in dispute for months, even sometimes a year, 2 years, but they may not necessarily have issued. So it's early on. And the thing I say to commercial parties is, when I'm told, well, why mediation? Why don't we fight it and prove that we're right? Well, there's two things. One, I spent many times as a lawyer. I'm sure Philip instructed me to give a percentage chances of a case, and we barristers and solicitors are very good at saying, well, I think you've got a 60% chance, 65%. We might even say 70. You won't go beyond that. Now, that still means you've got even if it's 70, it still means you've got a 30% chance of losing. But the harsh reality is, for as good as we as lawyers are, your odds in court are 50-50. If you've got a two-party case, one side wins, one side loses. There are plenty of cases that I had that I should have lost, that I won, and those that I should have won, that I lost. And why did it happen? Because that's litigation. Because a judge prefers a certain witness rather than another one on a factual matter. It's something you can't predict. You think your witness is absolutely solid on the facts, but you haven't seen how they're going to perform necessarily, but you certainly haven't seen how the other side will perform. You think your expert might be better than the other one, but you may be wrong. And all a judge does, you've seen the scales, is just doing this weighing act. And it's a preference, because a judge doesn't know what happened factually. The judge wasn't there. The judge doesn't know, doesn't have the grasp of expert evidence. And the judge will interpret a contract in a certain way. And there's always more than one way to interpret words. So you're talking about 50-50, and that's not brilliant odds. We're already in a situation then that we've got 75% chance of getting a settlement mediation, but only 50-50. But the real thing, and that's all fun, the real thing that I say to clients is why should you use, because it's up your street. Because it's what that in-house counsel said at London Disputes Week. We are not in the business of disputes, we're in the business of making money. And in the end, mediation is about doing a deal. And so I do construction mediation. What's the construction world really about? I want to buy 10 bricks, but I want to pay for only 7. That's what mediation is. It's about getting a deal. Insurers, what are insurers about? Insurers want to pay the least they can on any claim. Apology to any insurers on the call, but that's the reality. That's your commercial world. You don't pay out as the highest figure. You want to get a deal, and that's why mediation allows you to negotiate that deal. And so the key to it is thinking in that settlement mode is being in negotiation and being there. And so finally, what I would say, and I will pause, is why the good mediations work is because all I'm talking about, you may think, well, can't we do that by ourselves? Yeah. And you can. And if you can, then you'll do it. But the mediations I see, generally that's been tried, whether via solicitors or even parties. And what you move away from in mediation is a bilateral negotiation to actually a negotiation that is facilitated. And a good mediator really facilitates it. And actually helps parties. I never give parties the answer. I call myself an evaluative mediator with a small e. I will never evaluate the case and tell the party the answer, but I will do enough, and I don't leave my 33 years experience at the door to allow the parties to do a bit more evaluation along the way. And so the other thing what I say to solicitors and to clients is, when you're in the mediation, don't try negotiating with the mediator. You don't have to prove your case to the mediator. Use the mediator and let the mediator be used. Work with the mediator. And so I have this slide I put up and say, I want you to think of your mediator. And I put a Swiss Army knife up. And I say, think of your mediator as a Swiss Army knife, because they are going from room to room. They know what's going on. They're not telling you what's going on in the other room because that's confidential, and vice versa. But they have lots of tools to use. And so when they come in and they say, I think you should be doing this, this, or this, I think this could help, or don't do what you're suggesting, think of the Swiss Army knife. If they're saying to you, I want to go in the room next door and use the scissors, don't tell them to go in and use the corkscrew. Use the mediator, work with the mediator, because the mediator is working to bring the parties together to get the best that they can. The best that they can is generally both parties feeling some hesitation about it. It used to be, you say, both parties should be disappointed. I don't think that's the case. Both parties might think, the paying party might think, if I went to court, I'd pay less. The receiving party may think I receive more. And often you might have a settlement. You might wake up the next day thinking that I could have got more, I could have paid less. But by the time you get downstairs, you will find the coffee tastes better. And that's really what this whole talk is about. It's about making the coffee taste better the next day after the mediation, because it's then done. The dispute is done. Whatever would have happened at trial, you'll never know. But you've got that dispute. You've put that one to bed. There are other things to move on to. I kept saying I'll stop. I will stop. And I think we've got about 12 minutes for questions. So I can't see you, but thank you all very much for attending, and very happy to take some questions.
Andrew, thank you very much indeed for an informative and very useful, I believe, practical take on the process of mediation, things to bear in mind in respect of achieving a settlement if one can be obtained at mediation. We've got a series of questions that have arrived, the first of which is from Robert Wielden. Robert asks, are mediation statements shared with the other side? And if not, and one sets out potential weaknesses within a statement, might the mediator highlight these to each side?
So they're always shared with the other side as far as I'm concerned. Because you're both saying we're coming to the mediation, we're coming effectively in good faith to have the mediation, and this is our position. My encouragement to people to put their weaknesses is not always taken up. I'd say it's a minority is taken up. When it is, it's definitely appreciated, because you've got a place to start. What you said about highlighting the weaknesses of each side, a good mediator would do that, and styles vary. But as I said, it's not, I can't go in to a room and tell them what the judge is going to do. And there's two reasons. One, that's not my job, but two, I don't know. As I say, I could get it wrong. I got it wrong in my career, judges did that, that I didn't expect. But in terms of that, I might be sitting in a room and they will tell me X, Y, and Z as to why they're going to succeed on this point. My job as mediator is not to say to them, you are not going to succeed on that point. But my job is to say to them, what happens if you're wrong? What happens if a judge doesn't accept that evidence? Or let's put it another way. What happens if you are 100% right on that piece of factual evidence or expert evidence, but the judge gets it wrong? And that's the key to this. The judges don't always get it right, or what you think is what you think it is right. And it's making them think, it does, when I'm sitting in each part of the room, I say, what you tell me is truth. You tell me it, I'll believe it. But what if the judge doesn't accept it? What's it then going to mean? What the other side have told me, they think you are not going to prove X, Y, and Z. What if they're right? What does it then do to your case? But they're not right. I understand that. Of course, I'm in your room. They're not right. But what if they are right? Or what if the judge thinks they're right? Just work out what happens. And one I did recently, we actually had this, a bit like Punch and Judy. What if they're right, but they're not right? But what, just hypothetically, they're not right. And this went on for a little bit until someone else in the room said, it means we lose the case. And the penny dropped in the room. And we then moved very quickly to settlement mode to negotiation mode, because they suddenly saw that it hinged on quite a small point. And if that point went against them, as it could, it was game over for them.
It seems to me also that one has to factor into the production of a mediation statement a crystal clear understanding of the case, how the legal arguments are articulated, and how one sets out to prove one's case at trial with reference to evidence. And failure to do that with regard to an overall analysis of what is in dispute leads to a mediation statement which is not crystal clear and may make concessions in circumstances where it shouldn't, or be too bold in circumstances where some concession ought to be made, would be my view of that. We're asked another question by, and my apologies to Lanray for mispronouncing your name if that's so, but Lanray asked an interesting question. Bearing in mind that you're not there to act as a judge, how much of the litigation packs which lawyers tend to want to provide do you as a mediator read, and is your focus the mediation statement?
Personally, that's a really good question. It's a really good question. I read everything I'm sent, and it comes with a warning to the parties that you don't need to send me a trial bundle. Send me what I need to understand the issues, and I tell them, because I will read everything, and that will impact on how much I cost you, because the more I read, the more hours or days I spend on preparation, the more you'll pay. And sometimes they want me to read a lot more in, and that's absolutely fine. I had a mediation at the end of July, and they asked me, it was a very high value mediation, and the party said, we need to book out 2 days of your time for you to read in. We want you to be completely on top of this. And that's a lot for a mediation. And it was necessary. But for me as mediator, I see it as a difficulty when they're talking about something and I don't know about it. It's much easier for when they say, well, there was this meeting and blah, and I can say, you mean the June 2018 meeting. And it's not me showing off, but I've remembered. It's me being able to say, okay, I know what you're talking about. I know the context. I know the timing, etc. And it just means you're coming in. And I think the mediation world is split on this. There are some mediators who believe you go in as a blank page, and I don't fall into that category. The mediators that do the sort of work I do, I'd say the majority, if not all of them, fall into my category of I mean, a lot of us are a lot of past barristers, solicitors, etc. So we're used to reading legal documents and understanding them. So we fall into that category. Picking up on what Philip said, it's the merits are important, and sometimes the legal arguments are important, but the legal arguments tend to be the least important. Now, the mediator can pick up, especially if it's in litigation, can pick up the arguments from the pleadings very, very, very much. So that's why I always encourage you don't have to repeat everything that's in the pleading there, because the mediator will read them and will see what the arguments are. But the point is with mediation is if you stick to the merits, you won't ever have a settlement. The settlement is guided by the merits. It's sort of peripheral vision. It's there. But there comes a time in many mediations where you actually have to just say that you have to park the merits, because some settlements are not simply because of the merits. They're because of what's going on in the company, because of whether the company, the individual can afford to keep going in the mediation. The mediation I did yesterday actually settled for a relatively low sum because the claimants could not afford. They were two individuals in their retirement, and they could not afford to keep this litigation going. And their primary, they were, according to their lawyers, and it may have been the case, absolutely right. And if they'd gone to trial, which would not have been for another year and a half, they would have got more than they got yesterday, but they couldn't afford to go to trial. So the merits had to be parked. They had to get out of it today. As I said, they were both retired men who wanted to get on with, who needed to put it to bed. So I hope that's answered. In answer to using your words, Lanre, and I hope I'm pronouncing it correctly. You know, I will read the litigation packs, and sometimes, in terms of the mediation statements, are generally very important to me, but sometimes they're not, because they're just all they say is what's in the pleading. So it makes no difference to me, because I generally get the papers before the mediation statements. I actually prefer to get them at the same time. It most often happens that way. So sometimes they're used, sometimes they're not.
One last question. I think we've got time for 3 minutes left, so we do it very quickly. In terms of selection of a mediator, with reference to the fact that the mediator is there to perform the roles that you mentioned, contrasting mediator's position with that of a judge, how does one choose a mediator, and how does one ensure that the mediator that's put forward by the other side is not in some way biased in terms of links to the other side? Perhaps they're within an organization that's funded by the other side, or there's some connection in terms of the fact the other side instructs that mediator regularly as a barrister, or some other form of sort of social contact. How does one ensure that the lack of concern about a judge who would recuse himself or herself from a case, if they have such a connection with a party, is the case in the selection of a mediator?
So I think that's really important, and it's a really good question, Philip, because the starting point is, if you are well, first I was going to ask you, I didn't know there were any other mediators, but I'll leave it aside. But if you are a mediator and you are a neutral, you know, there's a lot in that. You're holding yourself out to a pretty high, you know, a pretty high standard. What I see, what you're talking about, is actually it costs clients a lot of money, and is often a waste of time, is an argument over mediators. And there tends to be this knee-jerk reaction. One party will say, I want to use, let's use my name, I want to use Andrew Miller. And the other side will say, well, if you want to use Andrew Miller, we don't want to use Andrew Miller, because there must be some reason behind it. Yeah. And for me, that's let's keep my name out of it, because it's the other way around. I want to use X, Y, and Z, and the parties say no, and I get the mediation because they're arguing over each side saying no to who it is. And I think the starting point, if someone has had a good experience with a mediator, it's not that, not like a judge, they've decided in one favor or another. The mediator's been good for them for a reason, has done something to facilitate a settlement of their clients. So they're saying, I know this mediator, I've seen this mediator who has been good. And the other side say, okay, tell me about it, or I'll speak to that mediator. So this knee-jerk reaction that often happens, I think really should be avoided. But I don't think you need to worry the second part of what you're saying. We don't have stories of mediators who are in the pockets of one side or the other. I mean, I'm still governed by the Bar Council rules, etc., in terms of what I have to do, whatever the right phrase is, integrity or whatever. That still governs me because I'm still a barrister. But I pride very much, as I know all good mediators do, on being a neutral. I am a mediator. Most of my mediations involve firms of solicitors that I work for, construction companies, developers that I may have acted for, certainly insurers, because Two Temple Gardens is a big insurance firm. All the mediations where I've had insurers, and it's a lot of mediations with insurers, at some time I work for one side or been retained for one side or the other as the council, but I'm coming in as a neutral. I'm not telling the parties what to do. I don't have a vested interest in it. So I don't think you have to be. I think what you have to do is when someone says, we think this mediator is good, take heed of it, and vice versa. When you're saying that, encourage them. But there's, you want to talk to the mediator. We're not all the same. Some of us bring something different to the table, and that's good. Some of us bring fireworks to the table.
Thank you very much indeed, Andrew. Thank you again. Very illuminating in all sorts of different ways, as one can see. And thank you all for joining this webinar. We've run over by 1 minute, possibly 2, so apologies for that. As I said earlier, we will pass on information, bios, scripts, and answers to questions that haven't been addressed yet. So once again, thank you very much.
Pleasure. And can I just say, anyone who is not linked into me, you'll find me on LinkedIn. Ditto, if there's any questions, don't hesitate to send me a message on LinkedIn or send me, I think my email's on there for chambers. Contact me, no problem if you have any questions on mediation. It's been a pleasure, everyone.
Morning.
Thanks very much.
Thank you very much.
Thank you very much indeed. Goodbye.
Bye.